We have covered so far the background relating to why the crimes are there, its significance, and what is the ground reality. And then we came to victimology and the persons who are affected, involved in a crime. That is something quite significant. And with that, would you like to now cover the criminal justice part of it for the benefit of the new faculty, emerging faculty?
Yes. Teachers who are into teaching criminal law should draw the attention of the students right away in your introductory class itself, after you've spoken about what are the laws, present laws, what is criminology, what is penology, what is victimology. You then have to move on to see why do we have these laws? It's all for justice, for a law and order situation, for a smooth life. And there, who plays a role when we talk of criminal justice administration? The criminal justice system in India. In India, we have the accusatorial system of punishment, where we would only call the person, the suspect, we call him an accused person. We cannot address him as a criminal until he is proved guilty beyond all reasonable doubt. My friends, I should tell you, in India and in our accusatorial system of punishment, you cannot convict an accused unless and until he is proved beyond all reasonable doubt. I am telling you, even if there's an iota of doubt in the mind of the judge, even if you and I were judges, even an iota of doubt in the mind of a judge, we will not convict.
It has to be resolved in the favor of the person who's accused.
Yes.
And by now he has traveled, he has come from that stage of being a suspect.
Yes.
Right.
Yes.
Okay.
But
witness, suspect, and now he is an accused.
Accused.
Okay.
But even when he is an accused, we cannot draw conclusions without getting clinching evidence that it is he and he alone who has committed the crime. That is where our criminal justice administration plays a major role. The police system, the prison system, the prosecutorial system, judicial system, they all have a role to play. Now, I will just quickly take you back to that point of accusatorial system, because we have the accusatorial system, adversarial system, with the two lawyers, the public prosecutor on one side and the defense counsel on one side, arguing both with equally strong evidence, trying to mislead the judge. The judge at the end of the trial sometimes is in a confusion whom to punish, and only the convict can be punished. Now, there we need to just make a comparison with France, for example, which has the inquisitorial system of punishment.
Okay.
In France, the judge plays a positive role. The judge plays an active role in the trial stage.
Now, but in our case, you have already underlined and underscored that number one, there has to be clinching evidence beyond all reasonable doubt. And secondly, doubt, if any, goes to the accused.
Yes,
and
he
you
has to be acquitted.
Also made a mention that accused may be deaf and dumb.
Yes.
He is not required to shift his innocence, and the burden is on prosecution to prove.
Prosecution.
Right, he has a presumption of a right to silence.
Yes.
Now, at what stage would you advise into classification of crimes?
Not exactly classification. I will just tell you what
Yes,
I wanted
or
to
offenses.
say.
Yes.
No, it's not that, sir. I wanted to say that in France, the prosecution can remain silent. The accused has to prove his innocence.
To the court. Okay.
You see the difference?
Right.
So that's why I say, and that's why the Malimat committee all teachers of law, criminal law teachers, please read the Malimat Committee report.
That is sort
Justice
of mandatory reading they should.
Yes.
Malimat Committee report. Okay.
Justice Malimat recommended that we should borrow some features of the inquisitorial system of punishment.
Okay.
Because here, the prosecution has to play a major role. And that is why I'm taking you to the criminal justice system, where it starts with the police, the investigation. We should have an efficient investigatory machinery. We should have an efficient police system. Otherwise, the judge is waiting for evidence and the prosecution is depending on the police to bring, he's the eyewitness. I got this handkerchief from the scene of crime. This watch fell off. Probably it was found in the scene of crime.
So, the clinching evidence or the foolproof prosecution, so to say, is the sine qua non that has to take place.
Now the prosecution is dependent.
Yes.
That's why I'm looking at criminal justice system as a whole.
Okay.
The prosecution is depending on the police to give them this investment.
Right.
The police is depending on evidence.
Okay.
Including expert evidence.
Okay.
It's a very important aspect. A doctor is called to give the evidence.
Okay.
The doctor has to depend on forensics also.
Yes.
So teachers of criminal law should have a background also in forensics. Because,
but here I would like you to spell out and create this doubt that in a 5-year program, this law of crime would be taught at a certain stage.
Yes.
But do you expect that the teacher should presuppose or should suppose that they already know the forensic, they already know the law of evidence?
No. Students would not know, nor would the teachers know.
Yes.
That is why we should, and we do that here.
Yes.
We framed, rather I introduced it even when I was Vice-Chancellor at NUALS. I saw that first they will learn the Indian Penal Code.
Law of crimes.
Law of crimes. Then the Criminal Procedure Code, then the evidence law, and then they will have a paper on criminology, penology, and victimology, and criminal justice administration.
Okay. Now, at what stage do the general exceptions come into play?
General exceptions are in the Indian Penal Code.
So,
the old Indian Penal Code, section 76, up to 106 deals with general
So, at what stage should this be taught, general exceptions? And what is its significance?
It's taught with law of crimes.
Law of crime.
Because law of crimes has 511 sections, the old one now I'm
Yes.
talking of, the other has 319.
Yes.
Out of which 76 to 106 deals with general exceptions.
Yes.
And 96 to 106 is right of private defense.
Yes.
Now, that's very important, which is taught with law of crimes, because suppose, the exceptions, one is insanity,
Yes.
unsound mind.
Yes.
Now, the lawyer would say, the defense lawyer will say that the accused was unsound at the time of commission of the crime. So, he cannot be convicted, because general exceptions, if you're unsound or if you're intoxicated, not voluntary, somebody else, you cannot be convicted. You will be acquitted.
Yes.
Because the unsound mind or the child below 7, they do not know the nature of the act.
So, anything particular that you would like to sort of
evidence.
lay emphasis on this general exception?
I will, because our premise is that the prosecution has to prove beyond all reasonable doubt.
Okay.
But if the defense is depending on general exceptions, that my client, the accused person here was of unsound mind, then the prosecution can stay quiet. The accused has to prove
Onus shifts.
The onus of proof,
Is
burden of proof at that stage shifts from the prosecution to the defense.
Okay.
But not to prove the entire guilt, but to prove that he was of unsound mind.
Yes.
To that extent only the burden shifts.
Preponderance of probabilities.
Exactly. And that is sections 106 and 7 of the Indian Evidence Act,
Okay.
which speaks about burden of proof.
So, you have covered both general exceptions and burden of proof.
That part of it has to be read.
Yes.
Yes.
We had so far covered the general background, why the crimes take place, and then we went into the victimology part of it, and also the general exceptions, the burden of proof. And in this session, we talk about crimes per se that are included. And my first question too is that out of 100%, how much weightage is to be given to the crimes according to you?
Just before going into it, I was just little wanting to, when I was telling about criminal justice system, that one should not forget, because when we talk of crimes, particularly murder and rape and all, I would have to refer to this. That is, I was telling about the prison system, prosecutorial system, judiciary, which has to ultimately render justice. And again, the judiciary, especially at the higher level, would depend on the evidence. That is where when we go to crimes, we have to, I was telling that you need to have a background of forensics. Because to convict the person, at the appellate stage, the judiciary is not going to go into evidence because they've already got it. But at the trial stage, when we talk of evidence and the role of forensics, I would ask teachers of law to do a little bit of reading. Even before your introductory class on forensics. Because forensics now we know as far as, because that's the murder, I'm going to talk about murder, one of the sections. We know about the narcoanalysis test, brain mapping, polygraphy, the lie detector test, ballistic experts who would say from what distance the shot was, or the shot, was it murder? Angle. Was it right at the back of the neck? Was it a murder or was it suicide?
So he
would kill and say it was suicide.
So to that extent, it
before talking about murder, I need to tell about forensics. And in India, so for instance, if we talk about narcoanalysis, the courts would go, we would immediately go to Article 20, Clause 3 of the Indian Constitution. Again, teachers of criminal law, if you're going to teach crimes, before you go to it, read Article 20, Clause 3 of the Article 20, Clause 3 of the Constitution. Because when you're going to talk about all the evidence, you should bear in the background that we have the doctrine of self-incrimination. Okay, now, when you move on to crimes, if I'm to teach criminal law, the penal law, I would start with murder and culpable homicide. I won't start with section 1 says or section 2 section. I never read the sections at that point of time.
So you would start with offenses against the human body and starting with murder.
Exactly. Why? Because, and I remember we did it at the National Law School, Bangalore. From the inception I was teaching there. Criminal law, we would start with murder and culpable homicide. Of course, first to bring them into it, we used to discuss cases like Dudley versus Stephens and all that, you know, to bring them into the feel of it. Now, the point of necessity and all that. You wanted to ask me something?
No. What I was saying is that, say, on ingredients of the offense.
I'm going to that.
Yes.
When you go into murder, you don't just go and start reading Section 300 defines murder, Section 302 gives the punishment for murder. Don't tell them the sections now. First, take them to concepts. We would begin with crime and murder because we first want to make them clear of concepts. I would start with concepts before talking about crime. That is, the concepts like intention, knowledge, motive, malice, recklessness, what role it plays in criminal law. So
the concepts have to be explained.
Before you talk about the crime.
Section per se.
And for the student to be conceptually clear, the teacher should also...
And the same approach would be there for offenses in respect of property, whether theft, robbery or extortion, etc. All.
Why? Because we all would study at the outset. That's why I was going to go to mens rea and intention. So I usually, sir, I start by asking students, before talking about murder, when I'm talking about intention, first they need to know the distinction between criminal law and civil law. You ask even seniors today, they would say the difference is that criminal law is governed by CRPC, civil law is governed by CPC, criminal law has a criminal procedure code. This has, that's not the distinction. I would not start off with murder. I would start off with what I'm now saying. What is the crux of it? What's the exact distinction between crime and civil cases?
Okay.
Why, if you are a judge, when you hear about a crime and it's all proved beyond doubt, you would say, okay, life imprisonment. But out of negligence, if someone has done something, and I'll give you an example right away. Suppose I've completed my 5-year law course and I want to go for an interview. I've been called for an interview. I was planning to join, say, Trilegal at Bangalore, one of the leading corporate offices, law firms. I would drive fast if I was told you have to be there at 10. Because of the traffic, I get caught up, or the signal, red signal, somehow there's a traffic jam, but I have to reach my interview point at 10. Now, when the signal is clear, now when you look, I have 10 minutes more to reach my office, I would press the accelerator and go faster.
Yes.
Against, I would say, you and me, we would do the same thing. We'll drive a little faster.
Yes.
Now, while driving fast, if you knock down a man and he dies on the spot, in criminal law, you have to look at the nature of the act. What has happened? Murder has happened. Someone has been killed.
Yes.
Right now, we won't use any technical term. What are the ingredients of an offense? One is, if you want to call it a crime, you had the intention to kill the person. Now, to teach intention, negligence and motive, we don't go to the dictionary. Oxford Dictionary defines intention as, no. Let's look at intention under criminal law. Why is the concept of mens rea so important? When I knocked down that man on the road and he died, now we have section 304A of the Indian Penal Code, which is amended. When Lord Macaulay drafted it in 1860, I asked my students how many BMW cars were on the road. Leave alone BMW, how many cars were on the road. But later, 304A was added by an amendment, and now rash and negligent acts is punishable. The new law uses the word driving. But what I'm trying to say is, if you are the judge in this case, and you get to know the facts of the case, someone has knocked down a man and he's dead on the road, what is the kind of punishment you will give? Not because I'm a law student, I expect any favor out of it. Like anyone else, you will be caught. But what is the kind of punishment you will give? What was my intention, my objective? I wanted to reach my destination at 10.
So you have brought out very, very sort of in a lucid manner the need to understand the motive, the mens rea, the motive, intent, preparation part of it.
Everything.
And these must be highlighted
Yes.
by the faculty to the students. This is very important.
Yes.
And we would stop here for this session, but the conversation would continue. Thank you.